Right now, as you're watching this video, tens of thousands of immigrant visa cases from 75 countries around the world are sitting frozen. Not delayed, not slow, frozen. And the U.S. Department of State has given no end date. If your country is on that list, and I will read every single one of them in this video, your green card process has been stopped at the consular level, indefinitely. And if you don't understand exactly what that means, what the exceptions are, and what your options are right now, you could make decisions in the next few weeks that seriously damage your immigration future. Stay with me. This is going to take about 12 minutes. And those 12 minutes could matter more than anything else you do today regarding your immigration case. My name is Raymond Crivello. I'm a senior immigration analyst and consultant, and on this channel, I break down complex immigration developments into clear, fact-based analysis you can actually understand. I don't do rumors. I don't do panic. I do policy, explained in plain language, backed by official sources. Before we go any further, a necessary and important disclaimer. I am not your attorney, and this content is for educational and informational purposes only. Always consult with a licensed immigration attorney about your specific case. Every situation is different, and nothing I say in this video constitutes legal advice. Now, let's get into exactly what happened, who is affected, and what you need to do. On January 14, 2026, the U.S. Department of State issued an official announcement. 7 days later, on January 21, 2026, that announcement became policy. The State Department indefinitely paused the issuance of immigrant visas for nationals of 75 countries. Not some countries, not high-risk categories, 75 countries. That is the largest single immigrant visa suspension in modern American immigration history. This decision came directly from the Trump administration's policy directive that immigrants must be financially self-sufficient and must not become what the law calls a public charge, meaning someone who depends on government welfare or public benefits. The State Department's own statement said, and I'm quoting from their official release, that this pause is intended to allow a full review of screening and vetting policies to ensure that immigrants from high-risk countries do not unlawfully utilize welfare in the United States. Now, I want you to understand something important before we go further. This is not a travel ban. This is not a non-immigrant visa ban. Tourist visas, student visas, H-1B work visas, those are not affected by this pause. This is specifically about immigrant visas. The visas that lead directly to a green card, to lawful permanent residence. This is consular processing. And for the nationals of those 75 countries who were waiting at embassies and consulates abroad to receive their immigrant visa stamp and come to the United States as permanent residents, that process is now on hold with no announced end date. Now let me give you the full list of the 75 countries. I'm going to read every single name because your country or a family member's country may be on this list and you deserve to hear it clearly. Afghanistan, Albania, Algeria, Antigua and Barbuda, Armenia, Azerbaijan, Bahamas, Bangladesh, Barbados, Belarus, Belize, Bhutan, Bosnia and Herzegovina, Brazil, Burma, Cambodia, Cameroon, Cape Verde, Colombia, Côte d'Ivoire, Cuba, Democratic Republic of the Congo, Dominica, Egypt, Eritrea, Ethiopia, Fiji, the Gambia, Georgia, Ghana, Grenada, Guatemala, Guinea, Haiti, Iran, Iraq, Jamaica, Jordan, Kazakhstan, Kosovo, Kuwait, Kyrgyz Republic, Laos, Lebanon, Liberia, Libya, Moldova, Mongolia, Montenegro, Morocco, Nepal, Nicaragua, Nigeria, North Macedonia, Pakistan, Republic of the Congo, Russia, Rwanda, St. Kitts and Nevis, St. Lucia, St. Vincent and the Grenadines, Senegal, Sierra Leone, Somalia, South Sudan, Sudan, Syria, Tanzania, Thailand, Togo, Tunisia, Uganda, Uruguay, Uzbekistan, and Yemen. 75 countries, spanning 6 continents. And here is something critical that many people are completely missing about this list. Several of these countries were not previously included in the Trump administration's travel ban list. Countries like Brazil, Colombia, Jamaica, and Albania, these are new additions. This pause goes beyond the previous travel ban. This is a separate, additional policy layer, and it carries its own consequences. But here's where this becomes critical. I want to explain the legal mechanism the State Department is using to implement this pause, because understanding the legal basis is the difference between understanding your rights and being blindsided. The legal authority being invoked here comes from the Immigration and Nationality Act, the INA, specifically the public charge ground of inadmissibility. This is a long-standing provision of U.S. immigration law. Under INA Section 212A4, a person can be found inadmissible if they are deemed likely to become primarily dependent on the government for subsistence. That's not a new law. It has existed for decades. What is new is how the State Department is applying it. Instead of evaluating each individual applicant on their own financial circumstances, which is what the traditional public charge assessment required, the State Department is now applying a categorical pause based purely on nationality. In other words, it doesn't matter if you are a doctor, an engineer, a business owner with millions in the bank. If your passport is from one of those 75 countries, your immigrant visa is paused. This is the legal argument that advocacy groups and immigration attorneys are already challenging. On February 2, 2026, less than 2 weeks after this policy took effect, a federal lawsuit was filed challenging this suspension. The argument in the lawsuit is that the State Department is exceeding its legal authority and that this categorical suspension conflicts with long-standing public charge standards established by Congress and the courts. That legal challenge is now working through the federal court system. Whether a federal judge issues an injunction, a court order stopping this policy, remains to be seen, but you need to know that this is being contested, and the outcome of that court case could significantly change the landscape. This is what many green card applicants are misunderstanding right now. They hear the word paused, and they think their case is dead. It is not. Let me explain what this pause actually means in practice, because the details matter enormously. If you are a national of one of these 75 countries and you are currently going through consular processing abroad, meaning your I-130 petition has been approved, you have been scheduled for an immigrant visa interview at a U.S. embassy or consulate outside the United States. Here is what you need to know. The State Department has said that immigrant visa applicants from affected countries may still submit visa applications and still attend their interviews. The consulates are still scheduling those interviews. But at the end of that interview, even if you are found otherwise eligible, your visa will not be issued. Consular officers are being instructed to hold cases under INA 221G, administrative processing, rather than approve them. Your case will sit there, processed but not issued, until the State Department completes its review and lifts the pause. There is currently no announced end date, none. The State Department has not told anyone when this review will conclude. Now I want to tell you about Amara. Amara is a composite, hypothetical case, not a real individual, but her situation reflects thousands of real families right now. Amara came to the United States from Nigeria in 2018 on a student visa. She finished her degree, got a job, and her employer sponsored her for a green card. Her employer-based petition was approved. She traveled back to Nigeria to take care of her elderly mother while waiting for her consular interview to be scheduled at the U.S. Embassy in Lagos. She had her interview scheduled for February 2026. She attended that interview, she answered every question, she submitted every document, she proved her finances, and at the end of that interview, she was told, "Your case is on hold. We cannot issue your visa at this time." She is not in removal proceedings. She has done everything right. She is simply a national of Nigeria, one of the 75 countries on this list, and she is now waiting indefinitely, separated from her job, her life, and her future in the United States, with no timeline given to her. This is not a hypothetical problem. This is the reality for tens of thousands of people right now. There's one detail most people are missing, and it's one of the most important points in this entire video. There are exceptions to this pause, and if you qualify for one of them, you need to know about it immediately. First, dual nationals. If you are a national of one of the 75 countries, but you also hold a valid passport from a country that is not on this list, you may be exempt from the pause. The State Department has confirmed that dual nationals applying with a valid passport from a non-listed country are exempt. This is a significant exception and one that many people haven't explored. Second, children being adopted by American citizens. The State Department has confirmed that children being adopted by Americans can qualify for a national interest exception under Presidential Proclamation 10998. American families in the adoption process should continue the normal process, attend their interviews, and will be considered on a case-by-case basis. Third, national interest exceptions more broadly. While not guaranteed, the process exists for cases that the government deems to be in the national interest. These are narrow, case-by-case determinations, and they require specific legal arguments made properly. Fourth, adjustment of status. And this is a critical pathway many people are overlooking. If you are already inside the United States on a valid non-immigrant visa, an H-1B, an F-1 student visa, a valid tourist visa, you may still be able to file Form I-485, Adjustment of Status, to obtain your green card without leaving the country. This pause specifically affects consular processing abroad. If you can adjust your status domestically, that pathway remains available to you under current policy. I want to be clear, I am not saying adjustment of status is guaranteed or easy. There are eligibility requirements, but it is a pathway that this pause does not close. And if you are currently in the United States on a valid status, you should be having a conversation with a licensed immigration attorney right now about whether you can file for adjustment. Now let me address something for people who think this doesn't affect them. This could affect you even if your particular visa category seems unaffected. If you are an employer who sponsors foreign national employees for green cards, and those employees are from one of these 75 countries, your green card pipeline has just changed significantly. Employees currently in the United States may need to shift to adjustment of status filings rather than consular processing. Your global mobility planning needs to be reviewed immediately. If you are a U.S. citizen or green card holder who has filed an I-130 petition for a family member abroad from one of these countries, a spouse, a parent, a sibling, that person's case at the consulate is now frozen at the final issuance stage. And here is something sobering about the new standards being applied even before visa issuance resumes. According to information reported by Mintz Law Group from a State Department internal cable issued in November 2025, before this pause, consular officers were already being directed to broaden the factors they consider in a public charge assessment. They are now looking at the health conditions of the applicant, including conditions of non-applicant family members. They are considering English language proficiency as a factor. They are requiring much stronger financial documentation, 3 years of tax returns, bank statements, proof of assets, and employment history showing immediate employability in the United States. What this means is that even when the pause lifts, and it will lift, either by policy change or by court order, the standards that greet those applications will be significantly higher than they were before January 2026. So let me give you a concrete, clear action plan. 5 steps you should take right now if you or a family member is affected by this pause. Step 1. Do not abandon your case. This is the single most important thing I can tell you. If you have an interview scheduled, attend it. Build your record. Get your case as close to ready for issuance as possible so that the moment this pause lifts, your case is at the front of the line. Do not let a scheduled interview lapse. Step 2. Gather and strengthen your financial documentation right now. Do not wait. Collect 3 years of tax returns, bank statements, investment account statements, proof of property ownership or significant assets, letters from employers confirming employment and salary, and any professional credentials or degrees that demonstrate your skills and employability. The bar for financial documentation is higher than it has ever been. Prepare for it now. Step 3. Consult a qualified licensed immigration attorney immediately. Not a notario, not a document preparer, a licensed attorney. If you are inside the United States, ask about adjustment of status eligibility. If you are abroad, ask about dual nationality, national interest exceptions, and what legal challenges may affect your case. An attorney can also monitor the federal court case challenging this pause and advise you if an injunction is granted. Step 4. Monitor official sources. Specifically, monitor travel.state.gov for any updates from the Department of State on the status of this pause. Monitor uscis.gov for any related adjudication holds or policy changes. And subscribe to reliable policy-based information sources, not social media rumors, not immigration Facebook groups, not YouTube channels that turn every update into a crisis. Accurate information right now is essential. Step 5. Be vigilant about immigration scams. Periods of panic and uncertainty in the immigration community always bring out bad actors who prey on vulnerable people. No one can guarantee a visa. No one can guarantee a waiver through unofficial channels. Any person who tells you they can get your visa issued right now for a special fee is lying to you. Report them to your state bar association or the Federal Trade Commission. Now let me put this policy into its broader context because I want you to understand not just what is happening today, but what could happen next and what that means for your long-term plans. The legal challenge filed on February 2, 2026 is likely to work its way through the federal courts over the coming months. If a federal judge grants an injunction, a temporary order stopping this policy, the pause could be halted while litigation continues. That has happened before with immigration policies under multiple administrations. However, there is no guarantee of an injunction, and legal proceedings can take time. On the legislative side, Congress has not passed legislation authorizing or blocking this pause. The State Department is acting under existing executive and administrative authority, its INA authority over consular decisions and visa issuance. That authority is broad and has historically been subject to what courts call consular absolutism, a doctrine that gives consular officers enormous deference. That deference makes legal challenges harder, though not impossible, particularly when a blanket categorical suspension is at issue. The State Department has said this pause is temporary, a review period, but temporary is doing a lot of work in that sentence. There is no statutory deadline requiring the review to conclude. No end date has been announced. The realistic timeline, based on how similar policy reviews have proceeded historically, is measured in months, not weeks. And here is the sobering long-term consideration. Even if this specific pause is lifted, the new public charge standards being developed during this review period will likely remain in place. The stricter documentation requirements, the broader health assessments, the English language proficiency factor, these are likely to become permanent features of the consular processing landscape going forward, regardless of what happens with this particular pause. I want to close with something that I think is important to say directly. Immigration status is not an abstract policy matter. It is family. It is the ability of a mother to be reunited with her children. It is the ability of a skilled professional to build a life in a country they have contributed to. It is the ability of a spouse to sleep in the same country as their partner. It is financial security, career stability, the ability to plan a future, and the foundation of years of legal work and sacrifice. The people affected by this pause are not abstractions. They are real human beings who followed the legal process, filed the right forms, paid the filing fees, waited in lines, attended interviews, built their financial cases, and who are now waiting with no end date in sight. That is serious. That deserves serious, factual, clear-eyed attention, and that is exactly what this channel exists to provide. Your job right now is to stay informed, stay documented, stay legally compliant with your current status, and work with qualified legal professionals who can protect your position until this situation clarifies. You are not powerless. You are not without options, but you need accurate information and you need it fast. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional, it's essential. If this video helped you understand what is happening with the 75-country visa pause, please leave a comment below telling me your visa category and your country. I read every single comment and it helps me know what breakdowns to do next. Share this video with someone you know who is affected, and like this video to support factual immigration coverage that puts people before politics. This is Raymond Crivello. Stay informed, stay protected.